Yes, there are. And I suppose as an addition to the answer to the previous question, if you are a small business, you have to have total debt that's under a certain dollar amount, about 2.7 million. Now, with the COVID-19 pandemic, Congress enacted something called the CARES Act and temporarily increased that dollar amount to 7 million. So there is a limit on getting into that subchapter 5 category of chapter 11. Your debts can't be too large. Now, there are some very real benefits to being a small business debtor under subchapter 5. I'll cover just a few. The first piggybacks on something that I already discussed, and that is getting the creditors on board. In a subchapter 5, the creditors do get to vote, but you can still get the plan confirmed even if none of the creditors vote in favor of the plan. Now, to contrast what happens in a classical chapter 11 to what happens in a subchapter 5, chapter 11, there is something that is a big hurdle called the absolute priority rule, which doesn't exist in subchapter 5. Now, what is the absolute priority rule? Well, creditors in a bankruptcy case, whether it's a chapter 11 or any other chapter, are treated according to the class that they're put in, because not all debts are created equal. For example, a secured debt, where there is collateral that the creditor can repossess in the event of a default, that creditor is treated better than unsecured creditors who don't have the option of repossessing some collateral in the event of a default. Even within the realm of unsecured creditors, we make distinctions between what are called priority creditors. Those are creditors Congress has elected to give special treatment, and non-priority creditors. Now, the way to think then of the plan is it's sort of like one of those fountains that I'm sure you've seen where there's a succession of bowls, and coming out of the top is a source of water. And that source of water has to fill the top bowl completely before water flows out to the next bowl, and similarly on down the line. So the image then is of those classes of creditors. So the top class has to be paid in full before the next class gets anything, and so on down the line. Now the bottom class is the debtor. So for example, the shareholders, the owners of the business, they're in that bottom class. Now, if you propose a plan of reorganization under a classical Chapter 11, and all of the creditors vote in favor of the plan, you're fine. But if some of them don't vote in favor of the plan, and you have what's called a non-consenting class of creditor, as long as you have a consenting class of creditor, that is a class that voted in favor of the plan, you can still get the plan confirmed. But that's what triggers the absolute priority rule, which means that that bottom bowl gets nothing unless all the other creditors get paid in full. So in practical terms, it means the stock that the stockholders own becomes absolutely worthless. And the only way that they can get any more ownership interest in the business is by adding new value to the business. And that has to be in the form of money. It can't be sweat equity. So in order to maintain any ownership in the business, if the absolute priority rule is triggered, the creditors have to add new value. But now, if the creditors vote in favor of the plan, if every class votes in favor of the plan, there is no absolute priority rule. So in a classical Chapter 11, one of the big goals is to make sure that each class votes in favor of the plan. Now, in subchapter 5, that's a subchapter of Chapter 11, there is no absolute priority rule. So even if you can't get any of the creditors to vote in favor of your plan, as long as the plan satisfies certain statutory requirements, the judge will confirm the plan, but you still get to retain your ownership interest in the business, or if you're an individual or a married couple, you still get to retain all of your possessions. So that is a very potent benefit to being able to file under subchapter 5. And to do that, you have to be a small business. Another benefit in subchapter 5 is the absence of what are called U.S. trustee fees. So in the classical Chapter 11, every quarter, the debtor has to pay a quarterly fee to the Office of the United States Trustee. And the amount that's paid is based on the amount that the debtor dispersed over that quarter. Now, in subchapter 5, you don't have to pay those. They don't exist. There is a little bit of a wrinkle, however. Under a normal Chapter 11, there's usually no Chapter 11 trustee. There is the U.S. trustee that does have some oversight in the case, but there's no chapter trustee that's running things. In a subchapter 5, there is a subchapter 5 trustee, just as a matter of course in every subchapter 5 case. That trustee's main goal is to get the plan confirmed, and they can be very helpful. I had a very good experience recently in a subchapter 5 case with one of the panel subchapter 5 trustees in our district. But that trustee gets paid. So it's sort of the left hand takes, the right hand gives, or maybe I should put it backwards. The right hand gives, or the left hand gives, the right hand takes away. So there are benefits, but then there is the cost of the subchapter 5 trustee. So there are a lot more things, of course, going on in subchapter 5, but for purposes of this somewhat informal chat, I think that gives a little bit of a flavor.